Well, good afternoon, friends. Welcome back. We are back with another talk show, which we keep curating from time to time on issues which involve analysis and review of policy and regulatory aspects, and of course, where we can impact in formulating the next course to make it more efficient for all the stakeholders concerned. We have today a panel to discuss the IT intermediary rules notified in April, I believe 6th of April, 2023. It's a very interesting set of rules. It kind of impacts the social media and largely the gaming sector intermediaries at the operator level, as well as down the line intermediaries, which we'll discuss. We'll try to curate a panel of very eminent experts who have impacted the formulation, or should I say the evolution of the policies and rules around gaming and social media for more than a decade. I'll try and give a very short introduction of the panelists and of course would welcome our experts and panelists to talk more about their journey over the years on issues which concern regulation of gaming and social media intermediaries. So we have with us today Mr. Ashish Chandra. Ashish has had a very long stint with social media and IT intermediaries. He's presently the General Counsel of CoinSwitch on the crypto side, but we specially sought him out and he very kindly agreed to come on the panel, owing to his deep exposure earlier at WhatsApp, eBay, and his journey around the formulation of Section 79 of the IT Act. I would request Ashish to elaborate on this as he gets his opportunity to start the opening remarks. We also have with us Mr. Samir Chugh. Samir is presently the Chief Legal Officer and General Counsel of Games 24/7. And again has a very long and illustrious stint as a general counsel on the telecom and IT and entertainment side. I'll request Samir to elaborate on it as we proceed further. We have with us Mr. Kapil Chaudhary, again general counsel of Junglee Games, one of the front runners in the gaming sector in India. And as general counsel, he has been handling and meeting and dealing with the challenges around the compliance in the regulatory space for many years now, and very successfully so. Welcome, Kapil. And then we have from the All India Gaming Federation, which is a body of the gaming stakeholders, we have Mr. Dhruv Garg, who has been specially nominated by the AIGF to put forward the views of the Federation in terms of their response, their journey towards formulation of the rules, and also their response and what they look at in the road going forward. Welcome to all the panelists here, and thank you for joining us today. And the process we would follow is to have an opening remarks from each of the panelists for 4 to 5 minutes, and then we move into question and answers. We have nearly 346 registrations and many more on the YouTube telecast channel. So we welcome comments and questions from our participants as we proceed. You could direct it to a particular speaker, or it could be a general question anybody could take up. Please put your questions in the chat box and we'll try and take them up as we progress with the discussion, or at the end, depending on the nature of question and the flow of the discussion. With that, I will pause here, and may I request Samir to kindly provide your opening remarks, and then we'll move on to the other speakers as well.
Thank you, Manoj, for this. I think, kind of Saturday afternoon, interesting conversation. This is really a topic which we've now seen for the last few months. In fact, I've been pretty lucky to be part of this, kind of to get this whole regulations, providing the inputs, etc. So clearly, from a gaming side and from a gaming industry, I think a fantastic way forward. I would really say that having worked in several, the IT sector, the telecom sector, this is a journey which probably is one of the most fastest journeys of the government moving from really, no regulations to regulation and realizing the potential of this sector. And I have to give that credit to the Honorable Prime Minister when he started to put his vision out to say that, kind of the gaming sector is really the backbone of the AVCG and it's going to be a huge part of the whole $1 trillion economy. And clearly, absolutely the right vision, because this is a sector which is a sunrise sector, has a huge potential. To give you some very basic numbers, very broadly, I may be off by a few million here, there, but essentially look at the US about a 400 million population, and the gaming sector about 280 billion market, right? Versus the Indian gaming sector, we have about 20 crore plus users across, and overall, kind of target market of close to 900 people, but we are still sitting at about a 20,000 crore industry. Yeah. So the fact is that clearly there is a long way to catch up, and the fact that the potential that this industry has here is tremendous. So having said that, kind of just to go back to a little bit of history on how the whole gaming piece and how it kind of fits into the law and the legal aspect is, I mean, clearly there is a difference. If you look at the law today, the law is very clear. There is a difference between what they would typically call as gambling, betting, and games of skill, which are kind of protected under the Constitution. And so Article 19(1)(g) provides that protection to all games of skill. I mean, this is not new. It goes back all the way to 1957, really, when the first Chamar Bagwala matter came in. And then there's been a plethora of cases after that, starting from Chamar Bagwala to Lakshmanan, to Satyanarayanan, to kind of in the recent times, the Karnataka, Tamil Nadu, Kerala, these high courts, in which, of course, Junglee games is one of the matters. We are part of that matter. And, all the matters that we all went and fought together, where again, it's been reiterated from time to time. So clearly, there's a difference between game of skill and there's a difference between gambling, betting. Gambling betting is illegal. That also falls within entry 34. That's the state remit. State can regulate or prohibit or do whatever it wants with the gambling betting side. But games of skill are something one that ideally should fall. It falls outside this ambit of the state for sure. But now it is being clearly stated that it falls within the center. And I'll tell you how that also has come about. So clearly, when this whole piece happened and this was continuing, I think the union government realized the potential, and then they started to look at this sector to really regulate it, given the fact that every new sector that there is a rise in or there is a growth clearly needs the right directions. And I think one of the big demands of the industry was, please regulate us, please put the right things in order so that this sector can grow. So I think it was about 8-10 months or maybe a year ago when we started to talk to the government. They were quick to understand. The regulations were started to think about. I think the first step that the government took was they turned around and actually amended the AOPR and therefore brought skill games in the ambit of the central government, and MeitY was made the nodal ministry. The MeitY then turned around and had some consultations and talking to people, and in very swift time, 2nd of January, they came out with the draft regulations, which was the amendment to the intermediary guidelines. And 6th of April, we had the regulations out there, which have been notified. And of course, it is extremely progressive. And why I say it's progressive is because they have gone with the intent of an SRB, which is a self-regulating body. The self-regulating body puts out all the rules, regulations, turns around and kind of registers the games, puts the entire framework for the registration, also what it needs to comply to for the registration. It helps register the companies. It helps make all of this clearly what was already legitimate, very, very clear in law. So I think we've seen a huge ambit, a huge movement there, within this sector. So if you look at the intermediary guidelines, they do turn around and cast a little more obligations on the gaming intermediaries. These gaming intermediaries are now are required to, of course, complete KYC as per the RBI requirement, which anyway we were doing already. So that wasn't something new, but clearly it has become more formal. Two, they will register with an SRB. Every single game that is offered will get registered with the SRV, which also means that the whole payment gateways, the whole banking system now recognizes it more, and it doesn't get treated as gambling betting anymore, which means that these are legitimate transactions. So that's the other big part of the regulations. The third, as I talked about earlier, but I'll elaborate a little more on it, is the SRB, the self-regulating body, which will be registered with the MeitY itself. So it kind of gets recognized by MeitY, then has its own process. It needs to have independent directors on the board who will run that. And there is a list of people that the government has set out who can be directors. It includes a psychological expert, a gaming expert, somebody, who's looking after the interest of the users, somebody who's, somebody who's got the whole consumer protection in at heart. And of course, one person who also the nominee of the government. So there are about 7 people that need to be as directors on the board. Those 7 people have complete independence. The requirement is to ensure that the gaming operators and the SRB are independent, and there is a complete, as I would say, independence of operation within the SRB, which means there's no influence, etc., no conflict of interest. In addition to that, there are the several other, requirements like a grievance redressal officer, a nodal officer, and then a chief compliance officer. Clearly, compliance is big. Compliance is the need of the hour, and of course, the right thing to do. With that, I think, there has been a tremendous movement where, as gaming industry or as gaming operators, we've welcomed this move. This also, will help take away the issue of how the states see this. And then I was talking about the gambling, betting, and the game of skill earlier. Basically, some of the states still equate this to gambling, betting, and therefore want to either prohibit it or come out with whatever, regulations that they want to, but it's mostly prohibition. South India particularly has had this issue in the past. Tamil Nadu is one state where, if I look at it, this is really 3 times in the last 3 years, where they have turned around and brought in laws which put a prohibition and a ban on, say, a game of rummy, right? Which is again the epitome of game of skill, because that's been settled in 1957 by the Supreme Court, and has continued to have that jurisprudence out there. But we've seen that in Tamil Nadu, they got out a law which was challenged in the High Court. So the High Court actually upheld our challenge and basically overturned the amendments that were made and the law that was brought in by the state. They went appeal to the Supreme Court. There's no stay there. That matter is still pending. They then got an ordinance last year, which was also challenged, but they came into the court and said the ordinance is not really enforced, so therefore there is no need to challenge. So we withdrew our challenge and we went back. But very recently, they've got the act again. So now we've gone and challenged that. That's sub judice. It's in the court, so won't talk about it much. But yeah, that is where it is. We had similar issue in Karnataka, but the Karnataka High Court, the Honorable High Court, turned around and overturned the amendments made by the Karnataka state. So again, that was a victory to show that, yes, games of skill are different than gambling, betting. Kerala, we had a similar situation where, again, the courts, stepped in and overturned what the state was putting. Andhra, Telangana, unfortunately, is still in court, so it is sub judice. But yeah, this is one big challenge which we believe post these regulations will go away as the games start to get registered, as these are recognized, as this is more regulated, as there is more compliance, as there is more formality to all of this. So I think interesting times ahead. A lot of work has been done, a lot of work to be done. And I do believe, I think it's the right path for the gaming industry. I'll stop there and, kind of hand it back to you.
Thank you so much, Samir. In fact, that was quite elaborate in that short span that you spoke, validating it as progressive, and of course the rules trying to add a lot of legitimacy to this whole process of recognizing certain games as games of skill, and therefore the entire system accepting them so that all stakeholders can have more confidence to play, to engage, including the users, which is the most important and crucial piece, because usually before, in the past, such games which had money involved were looked upon with a lot of suspect, and the
Yes.
huge market of people who really want to play the games for obvious reasons, but would step back and say that, we put in the money, we don't know who's going to help us get it out. With the very clear banking system supporting it, recognitions and SRBs, I think it goes a long way. And as you said, we'll discover some of the challenges and try and cover the ground there as well. Ashish, may I now request you, especially for your long engagement on the issues around social media intermediaries and the formulation of Section 79 days, and lot more that you have to share. Uh, Open remarks from you, and then we'll take up the Q&As after that.
Yeah, thanks, Manoj. And I think I'll just start with a basically giving you a summary of how I personally have witnessed the swing of the pendulum over last almost 2 decades. Then I think maybe in the next phase of my of my talk, I can just do a bit more nuance on the law. If that's okay with you, Manoj, I'll just
Yes.
spend a few seconds and then we'll do it later. So, I think and I'll only share my journey, my experience of, let's say, few cases and all, right? So, actually, my journey in handling this intermediary regulation or the questions of intermediary, safe harbor, intermediate regulations of 2011 and all started when I started working for eBay way back in 2004. And I mean, at that point of time, we were facing like the first test of law in terms of who's an intermediary, what's the liability of intermediary, can the intermediary sustain the safe harbor provision of Section 79. So, it was the infamous DPS MMS child pornography case, and eBay acquired Bazi in 2004, and there was some sort of vicarious liability on the CEO as well as on one senior manager. So that was the very first time this law was tested. But how the pendulum actually swing, if you see that right from the year 2000 when Information Technology Act was enacted, right? So this industry, which we see, it's like digital India, so many things happening online, gaming, crypto, or whatever you may say. At that point of time, we were nothing. I do remember when we used to go and meet the government, the enforcement bodies, even investors. When I was with eBay, we were being laughed about. छोटे बच्चे वीडियो गेम खेल रहे हैं आकर के टाइम पास कर रहे हैं at that, and I am talking about 2004, right? So we were like totally ignored. Some innocuous law was passed without thinking about how it is going to impact the growth or degrowth of the industry. But I think in 2003 and 4, when this case was there, the first time it was a wake up call for the government that look, we have made some law which we need to relook at it, whether it is going to really promote the growth of internet in India. And a lot of things happened, and a lot of debate and discussion with the government, industry body and bureaucrats, law enforcement agency happened. And thankfully in 2008, the core section of 79 and the core definition of intermediary was changed. And I think after that, we saw a hockey stick growth in the internet business in India per se, whether it is content business, whether it is e-commerce, whether it is online payments, whether it is the early avatars of, let's say, online gaming and stuff like that, because that gave a kind of breathing space for the founders, for the investors, for the employees to really build the business with a safety net of law in India, which was not available prior to 2008. And especially after this eBay Bazi case, there was a lot of concern, anxiety, FUD, okay, in the crypto world, fear, uncertainty, and all, right? So this 2008 was the watershed moment for the Indian jurisprudence to give that kind of safety net for entrepreneurs to take the bet and all. But then the industry grew very fast, and this law was being extremely open-ended for the industry, gave excellent safe harbors. But when internet took over our society, right, because of WhatsApp and Facebook and Twitter and Google and all stuff like that, including Indian platforms and all, right? Then our societal norms, our societal behavior started to get influenced or started to get reflected because of the activities happening on internet, right? So it was a shift from a totally ignorant to a totally buoyant law, which gave extreme freedom to internet intermediaries to really scale up their business. And when the business scaled up, people started to see that although it has a great upside, but there was also a bit of downside because our demography was also learning how to really understand the negative impact of social media or the internet intermediary. And then your government again woke up and said that, look, this has now become a too big an industry for me to have a totally hands-off approach. I need to really step in. And then there's some debates and concerns and discussion happened at Indian Parliament, various courts, which I can come to it later, which then led to the reenactment of the intermediary guidelines in 2021. So this 2023 amendment, which happened in April, this is the second amendment to the parent intermediary guidelines, which were reenacted in 2021, which made a very comprehensive, governance standards for your social media intermediaries or significant social media intermediaries. I can come to it later whether it's a boon or a bane, and what it takes to build a social media empire in India. But that's how the entire legislative kind of development has evolved, keeping in pace the growth of the industry and keeping in pace the impact the industry had on the Indian demographic. And in my next phase, I'll go a bit nuanced on how the jurisprudence and the various, like your legal nuances, changed over the last 20 years.
Thank you so much, Ashish, and we would love to hear more on the need and how does the 2023 rules pan out compared to the earlier regime we had, and therefore what are the changing parameters that we see, and how ultimately whether it's a boon or a bane, and what can we do to remove some of the difficulties which you perceive. Because one of the important part of this exercise that we're doing as we speak is that we also, at the end of our discussion, follow it on with our bit of contribution to the policy refinement process. So it doesn't just end here. This goes live and remains live permanently on YouTube for anybody to pick up the threads at any point in time, and also to pass on and to push the thought process into the lawmaking and policy formulation process for way forward. It has always been welcomed, and we have seen significant impacts of such contributions, and we continue to do that. Kapil, may I now request you to share your opening remarks? I know you have a long list of thoughts and ideas, and very interesting ones from our discussions today morning and earlier this week, with your opening remarks, and then we'll take up specific questions from you.
Thank you, Manoj, and thank you, Samir and Ashish, who've spoken before me. I'll keep the opening remarks pretty brief, Manoj, given a lot have been covered. So, let me put it this way. The online gaming rules definitely are a watershed moment in India, both from a regulatory standpoint and from the fact that now we have regulatory certainty and clarity, and the industry is moving from an unregulated industry to a regulated industry finally. Now, there are very interesting themes which have emerged under the online gaming rules. And, I think I'll probably break them down into 3 or 4 key areas for ease of understanding of our viewers. Firstly, the Honorable Minister, Rajiv Chandrasekhar, has very categorically stated that the field of online gaming will now be occupied by the union, which is the MeitY. So Samir spoke about entry 34, list 2, which is betting and gambling, which is taken. Now, this is actually the internet, right? So everything that happens online, entry 31, list 1, there is a clear demarcation laid down now by the Indian government that anything that happens online, especially in the gaming sector, is a field occupied by MeitY. And there are several nuances to it. There are obviously implications on how the state governments will react to that. But that's the first thing that happens with these rules coming into play. A second thing that I'd like to really call out, and I think this is again reiterated throughout in the rules, is that not only we have a very well-defined framework, we are also now talking a lot about responsible gaming and player protection, right? So what these rules really do is, at several places, they use expressions like user harm, psychological harm, and they've kind of kept user harm pretty open-ended to say anything that is detrimental to the interests of users, right? So these are essentially European themes, especially the UK gambling law themes around responsible gaming, responsible and mature gaming, which actually a lot of the mature operators in India are already following, right? All the companies on this call today are already following these rules through multiple self-regulatory codes of conduct. What these rules do is they actually effectively codify that. And there are 2 or 3 places where it's been called out. So one, the board of directors of the self-regulatory boards, which are going to be appointed, need to have people who are going to be psychologists, right? Who are going to be child experts, educationists, right? So the government has made its intent clear that you need to appoint people on the board of the SRBs who will take care of these interests while verifying a game as a permissible online real money game. Secondly, one of the key criteria that's been called out also, which the SRB will utilize, right, while approving these games, will be player protection. So they will look at, and this is also laid out very clearly in Rule 4A, Sub-Rule 8, which is, they will look at aspects like psychological and mental health, financial fraud, player exclusion. In fact, there are also now themes emerging on players, which, by the way, companies have already started putting into place, which is player exclusion, right? Which means a player who feels they are going over a certain daily limit will have the ability to exclude themselves, right? So that prevents user harm. So I would say, Manoj, that this is consumer interest, player protection coming into play through regulation, which is a very welcome step. The fourth key pillar of these rules, and I think we touched about that, is the state and the center distinction. How will the states react to it? Samir spoke about the challenge in various states. AP, Telangana, Tamil Nadu are key examples. We'll see eventually what these high courts rule, and what are the reaction the state governments will really, take to these rules. I would say the minister's expectation is for the gaming operators to start advocacy exercises around the rules. So, now it's also incumbent upon the industry players like us to talk to the state governments, engage in a dialogue, and actually say, look, this is a well-defined framework now being put into place. So we will then expect, the states to kind of hold back their hands on at least regulating the online gaming field. So I'll probably stop here. My 5 minutes timer is up, Manoj, and I think happy to answer more questions. But I just wanted to lay the field open to say those are the key 5-6 themes emerging. Very welcome step, and I think this will further what the industry has been asking for in terms of innovation, more innovation in this industry, which is the sunrise sector. Thank you.
Well, thank you, Kapil, and I think very interesting points there about the way the entire rules are structured to give more space and autonomy not only to the operators but also to the users, so to say. You have your self processes. That just reminds me of the way things have been panning out on the privacy side as well, where we have best practices which are probably already being followed at the highest quality levels, but then we don't have the law. So compliance is still a challenge. So we're kind of self-complying in an anticipation that in case a law does take shape tomorrow, or till that takes shape, if I'm to be tested on guaranteeing protection of data rights of users, then I can still meet that test. So therefore, in the absence of law, we've always seen much higher level of quality of compliance, self-compliance, and self-processes put into place, which, as you rightly said, is already there. And the codification is in a way validating the approach that you have had so far, that this is what is required. And therefore, it's more a validation, and also helps that you can now tick the box for compliance, and therefore the entire system, any regulator, any stakeholder can rely on the law, and the trust levels improve. And also user autonomy is something I would love to hear from everyone, because after all, the risk that somebody would want to expose themselves to in this whole process of a game of skill is something which should be protected. That's the appetite. It's of the user, and the user wants to take that risk. The user sees this as an opportunity, as much as India sees this to be a very significant part of the 5 trillion economy. Where does the two match? Ultimately, you have to allow this sector to become a biggest contributor to the 5 trillion economy. And to become a biggest contributor, the money has to come from the users. And therefore, the users have to be protected from misuse. But at the same time, they have to be given the freedom that they deserve and they need to be able to play up. So that's a very interesting point. I would love to hear a lot more discussion around that from everyone. And of course, before we move on to specific Q&As, Dhruv has worked very extensively with the AIGF, the All India Gaming Federation. And when we had a conversation with the CEO of the federation, that we want somebody to be there at the panel to represent the views of the federation, he didn't even blink his eyes and said, okay, my person is there who has helped us and worked with the federation and contributing to the policy formulation process. And Dhruv's advocacy skills go a very long way in his career on the policy side. Dhruv, welcome on the panel, and some opening remarks from you.
Thank you, Dr. Manoj, and thanks to all the panelists. I think most of the key points have been covered by the three panelists. Samiji has given a brilliant sort of a outlay of what the law is.
That always happens when you come number 3 or number 4.
Yeah, but I'll sort of try to pick like some pointers from each and try to give a perspective on that, or elaborate on that, and also sort of go into how the industry generally is looking at it very briefly. So what I speak on behalf of AIGF to give a context where it is coming from. So AIGF right now is about 150 members from the gaming community. They span from different formats, from real money or pay-to-play formats to free-to-play formats to game developers, correct? And now going also into blockchain and Web3 games as well. So my perspective or AIGF's perspective are coming from that varied experience. As Samiji has said that though the conversation around the rules started happening in last 1 year, to be exact, the first industry consultation held by MeitY was on 7th of June of 2022. The conversation started a few months before that, where a lot of questions were being raised in the parliament, different government functions were getting interested, and AIGF and other industry partners had always sort of pushed that there should be some regulation. And why was there an ask from the industry and why the government was interested in such a regulation? That's the context that I'd like to go in. As Samiji has also said that right now India has about $2 to $2.5 billion in terms of the size of the industry, correct? And 60 to 80% by some estimates are the pay-to-play formats. Now, compared to that, the world online gaming industry is about $230 to $250 billion. So we are only 1% of that international market. But still, we have about more than 450 million gamers, correct, which is larger than the population of some of the countries that we've talked about already. So in that context, whereas we have the total available market is so high, still our industry is very nascent, but still going at a CAGR of about 30%. So what we know is that the total available market is quite huge. Our year-on-year growth rates are around more than 30%, which is fantastic. And going to 5% of international market is not a big deal. But what we needed some stability, certainty from the government side. And in this context, the industry was, let's go and ask the government that there should be some regulation. So there's uniformity on approach by everyone. Also, the problem was that because, as Samiji said and Kapil has talked about, that there was fragmentation on state level. So these regulation will help in that. Another perspective that we want to put it as, like for example, in AIGF, we had something called a skill gaming sort of council, where it was headed by former Supreme Court Judge Vikramjit Singh, and they were already acting on a voluntary self-regulation basis. The members were already following a charter, a framework, sort of certain due diligence measures already. But what was happening is, if you see right now in India, there are about 800 to 900 gaming companies totally, correct? But people who are following those self-regulatory measures were voluntary self-regulatory measures earlier were only maybe 150 to 200 companies. The other 600 or 700 companies, we do not know what kind of measures they were doing. To bring about, so even everyone wanted to do the best, but to bring about some uniformity, you needed the government to step in. So in that context, to macroeconomically see, to grow that market, the regulations were needed. To improve, to sort of double down on the fragmentation of regulation across state, we needed these regulations. To bring uniformity into perspective of user safety, we needed these regulations. So in that context, what the government did is, they said that we will give you the guardrails in the form of user safety and law, and within those guardrails, you go and innovate. We'll give the SRBs to formulate their own framework as to how they'll verify the game. Till the time you take care of user interest and safety, we are fine, we will support you. So that is the perspective that the industry, or a policy perspective that the industry has seen these regulations come, and that's why they are very well.
Well, thank you so much, Dhruv. And with the opening remarks is already a lot more clarity and information around the rules that we have. Now it's probably some good time to take up some of the nuanced issues. May I start with Samir? Samir, suppose you touched upon particularly the issues around the SRBs. Would you want to elaborate on, apart from the constitution, how the SRBs roles and their, how they're expected to conduct themselves, how they facilitate the growth of this entire sector, how they're supposed to balance out the stakeholder interests? Do you see any conflict zones amongst the stakeholders which may ultimately be at the doorstep of the SRBs? And what's your anticipation, or your thinking how the SRBs would be able to handle? So the entire SRB bucket, wanted to hear your views, and then we take it to the other panelists as well.
Sure. No, so absolutely. See, I think, as I stated earlier, SRB itself, I think, is a very progressive situation, because this is not really somebody in the government or a government department sitting and regulating or really, kind of managing it, but it's basically an independent body which turns around and then regulates and ensures the growth of the industry, the registration of the games, etc. So if you look at it from the perspective of the regulations today, the regulations provide for the fact that there are SRBs to be formed. I'll just kind of touch on various aspects of it. So clearly, the first point there is that the SRBs are required to be formed. These rules actually come into force only after at least 3 SRBs have been formed and notified, and therefore 3 months have elapsed, because rightly the government wants to give time for the formation of the SRBs. Formation of the SRB requires a Section 8 company. I mean, those things don't happen overnight. So it has to, it'll take its time. But obviously it has to be done very, very quickly. So a Section 8 company is what an SRB will be. Now, clearly, one of the start point of the SRB is that they are required to be independent. When I say they are required to be independent, obviously there cannot be any conflict of interest, but it still needs to be incorporated. So if you look at it from the perspective of the MeitY guidelines, look at the Companies Act, you need members to incorporate a company. But on the other hand, you obviously don't want the members to be involved in everything, because at the end of the day, that company or that SRB has to act independently, which is where they put the board of directors. Right now, Kapil also mentioned about it. If you look at the constitution of the board of directors, really, to ensure the independence, they have thought through it, and that SRB does require, kind of individual from a particular field. And I'll just take 10 seconds or 20 seconds to just say, so the way the regulation reads is, it needs an individual having special knowledge of the online gaming industry, then an individual who promotes the interest of the users of online games. That's a big, big part of the SRB, actually, and I'll talk about that as well. An educationist that needs an expert in the field of psychology and mental health, somebody who has special knowledge or practical experience of information communication technology. Ultimately, all these are online games, right? These are games which are played on the mobile. These are games that are played on the internet. Information technology, IT and communications, of course, holds a big space out there. Then somebody who has been a member or officer of an organization dealing with protection of child rights. So again, you can see the user harm being ensured, that there's no user harm. Safety of children, that means below 18 cannot be playing. So those aspects have also been put onto the SRB. And then the seventh is really, kind of an individual who is an experience in the field of public policy. And that actually has to be nominated by the ministry. So ministry is actually turning around and nominating a member on the board, which means the independence and the functioning of the SRB is critical. Now let's look at, before I go back into how we ensure independence or what the possible options are, I'll talk about, really what the role or the requirements from an SRB to do is. The SRB needs to turn around and formulate the rules of a game. They're required to register the companies or the operators as their members, and are also required to register the games. Now, if you have to do that, that means you have to turn around and put the regulations and the way the game is played. Ultimately, we go back to the part of game of chance, game of skill. Clearly, a particular game that has to be turned around and be considered as a game of skill must pass the muster of law. The muster of law is that it has to involve predominant skill in it, and that it cannot be chance, and predominance test that has been laid down by the jurisprudence must be done. Therefore, the tests for these games are very important. So therefore, the framework as to how every game will be tested on merits to say whether this falls as a game of skill or not is very critical, because ultimately the companies will need to, or the operators, what they call as online gaming intermediaries, will need to provide an application to the SRB along with its the details of its game, how it's played, kind of show them the demonstration, the code, etc., all of that, to ensure that this is really a game of skill, and that there are no bots, and that there is nothing that can be done, kind of by the operators, such that the operators are taking advantage of it, and it is just a platform that is provided by operators. So the rules around the registration of the game, the rules around the compliance going forward, right? Then in addition, the SRB will also have to ensure that if there are grievances that are coming, now it could be that there are players, there are users, because user harm, user protection is important. Kapil kind of talked about it. I'm sure he'll elaborate a little more. So I'll probably keep it to the minimum and allow Kapil to kind of really go into that more detail. But user harm is important. Therefore, the ability for companies to have and to ensure that no player below 18 plays. We already do all of that. In fact, just to put one small point and add to what Kapil said earlier, today as EGF, we already have a responsible gameplay framework, which provides for what are the various things we need to do. He talked about a very important thing about limits. So today we actually follow the regulation or our own self-made thing, saying that if we see somebody getting addicted, we actually put a ban on it ranging from 24 hours to 6 months, saying you cannot play here. And we want to ensure that this is responsible playing, and that the fact that, players are not, or users are not harmed. Going back to the SRB, so therefore the SRB then needs to make sure that whatever gameplay rules, etc., are made are completely kosher and does not get influenced by the operators, which means that those are the rights that they will have. Those are the decisions that the board itself will take. Now, the companies, of course, need to form it. Therefore, there will be a formation. There'll be members, etc. But as that happens, the AOA of the SRB will turn around and detail all the rights and obligations of the board, the ability of what they do, the powers that they have to implement and to enforce the rules, and for the operators to follow. Now, in addition to that, if you go further, then the SRB is required to, when I was talking about the grievance, etc. So if there are players who come and complain, then there has to be somebody who has to listen to what the problem of the player or the issue that, or the concern that the player is facing, which then needs to obviously be resolved. You cannot resolve that by just listening to one party. You have to give the operators an opportunity to come and explain and sit on it, adjudicate. If you are able to determine the problem, you kind of, pass an order against the operator, or you tell the player it's not really an operator issue, it's something else. You resolve that. Therefore, the operator, so the SRB has to again, play that adjudicatory role there. and then enforce it. Now, if there is a problem between people, in the sense when I say people means whether it's a user and an SRB, or a user and an operator, any further, kind of dispute has to go to the grievance appellate committee, which is formed by the MeitY itself. Now, that is another level to ensure that there is fairness and level playing field. Then, in addition to all of that, the SRB, of course, has to have its own secretariat to run day-to-day operations. There's a lot of administrative work. When applications are made, people will have to scrutinize it. For the experts to look at it, it could have a advisory body of experts who could turn around and provide them the kind of detailed, what I would say is technical aspects of the gameplay, etc. So clearly, the SRB body has a lot of work cutouts in its hand. Independence to be maintained by board to have most powers, especially around the powers that impact gameplay, rules of the game, registration, etc. The members will probably have the right or will have the obligation and therefore the ability to also state what is the kind of contribution, because every organization, whether it's an SRV, whether it's a related entity or whatever, needs money to run, right? It has a secretariat, it has people, the contributions have to be made. That will have to be done by the members. The members could look at various options. It could be by way of certain, kind of yearly charges, whether that's dependent on some formula. Those formulas will have to be worked out as well. I think that is really the broad piece on the SRB and the SRB's main area of focus and the requirement for it to be independent.
Thank you, Samir. Before we move on to Kapil and Dhruv, Ashish, your thoughts on how do you see the?
So Manoj, I would suggest, because it's a gaming heavy kind of a forum, so maybe an audience would be so mesmerized with Samir's kind of narration. I would request if you could first continue with Kapil and Dhruv, and give me just last time in 10 minutes, because I'm sort of odd man out. Don't want to break the thought process of the audience on the gaming side, if you don't mind.
Well, we will turn to you on the SRB structuring, whether it's a boon or a bane. After you've heard, the judgment will be at your desk. So.
No, let me enjoy the game of skill over here for the gaming lawyers.
Yeah. Kapil, may I request you to touch on the SRB structure that is provided? I personally have my own questions, which I didn't want to load too much on the questioning or negativity side, but the experience that we've seen in some other sectors where without a legal backing, SRB kind of a structure has been in place. The broadcasting or electronic media is a very classic example. And we did try to work around the gap between the absence of law and the self-regulating bodies in the media side. We put up a bill as well, but then the dispensation changed and the whole initiative fell through. At that time, we had the opportunity to sit across practically all stakeholders on the broadcasting media. And some very interesting discussions came about, especially about the law should just be on the fringe and enable the sector to evolve by itself and make set the norms, which are balancing norms between the users and the operators, so to say, which kind of remains here as well. But then there have been issues from time to time around how, or questions around how the self-regulating bodies in the media side operate and perform or conduct themselves. And direct questions are asked about what Samir very lucidly kind of put it at the end in a very short way that it will evolve in future. But questions have been asked about who funds these bodies, who does the appointments, and therefore who are they answerable to in reality? Are they really answerable to the users? Can the users question their conduct? Apart from going to an appellate forum to the ministry, which a user may be too differently placed to be able to pursue that line as well. So if we were to, at the practical level, imagine that the relief available to a user starts and ends at how the SRB conducts itself. After that, it's the appetite and the energy level and the resources of the user compared to the resources of the operator. The resources are actually fighting, not the user and the... So these are questions which are there, and I'm sure we need to beat them when it comes to the SRBs on the gaming side. So your thoughts on how we could create the highest level of best way forward for a world-class SRB structure in India, and of course anything else you want to touch on.
Absolutely. Thank you, Manoj. And I'm mindful we have about 40 minutes left. We'll also let the other panelists get a chance. What I'll do, Manoj, is that over the next 5 minutes, quickly cover the grievance redressal mechanisms that have been set up under the rules, and then kind of take on any associated themes. Now, very similar to the structure that was put forward in the rules already for the social media and the significant social media intermediaries, Twitter, Facebook, WhatsApp, what have you. Since the same baseline approach has been adopted in the rules, a user is really well protected, and I would say, I'll just demonstrate for the purposes of this panel and our audience how that is going to be achieved under the rules, right? Now, the first protection that the user gets simply is by the online gaming intermediaries appointing a resident grievance officer, right? Which basically means a user, let's say a user is aggrieved or they're unhappy to say that my deposits have not been secured, right? Now, how that is covered in the rules already is that in our terms of service, all of us, which we are already doing, by the way, today, are supposed to clearly call out what are our deposit policies, on what basis can a user, is essentially all the rules of engagement will have to be very transparently put forward. And by the way, also, Manoj, a very interesting side note to this is that the latest TDS changes that have come in, right, which, Sameer, myself and others in the industry worked very closely with the CBDT, is that we are already demonstrating on our terms of service on our websites a clear mechanism on how a user can see their tax, their tax implications, the TDS implications, which are applicable, right? So firstly, a user sees clearly the withdrawal terms, the deposit terms, the policies. Secondly, their first course of action or first recourse would be to the resident grievance officer. Now, the resident grievance officer has to be, just like the chief compliance officer, it has to be a resident Indian. It has to be a full-time employee. There is a lack of clarity in the rules, but it's permissible for a company to appoint a single person as a compliance officer, the RGO, and the nodal contact person, although each of them would have very heavy roles to perform, which I can kind of vouch for based on my stint at Twitter. These three roles tend to be very busy. Now, what's going to happen is that, let's say a user files a complaint, the grievance officer will have 24 hours to acknowledge it, right? So there'll be an automated response that will go out. We've received your complaint and we are working on it. There is also a requirement to assign a ticketing-based system. So now companies, the online gaming intermediaries will have to make sure they're tracking every user complaint to a unique ticketing-based system. So at any point in time, a user has clarity on where my complaint is. Now, what happens once the complaint is received, the grievance officer works internally through the other stakeholders and has to resolve that complaint within 15 days at the very least, at the outset. If the user, by the way, is still unhappy with that redressal, they have then an option to go to the grievance appellate committee, right? The GAC, which the MeitY has already set up or will be in the process of setting up. It will have government nominees and others. The grievance appellate committee, therefore, becomes a second level of protection for the user. And the grievance appellate committee, what they do is they have 30 days from the date of receiving that complaint to resolve that user dispute. But it doesn't really end there. The grievance appellate committee also will be accountable and work very closely with the SRBs, who, by the way, may not also have their own grievance officers, right? So it'll be a triangular system, Manoj. There'll be the MeitY, there'll be the SRBs, and there'll be the grievance appellate committees. And between these three mechanisms, the user will be very well protected. Now, let's say the grievance appellate committee examines that complaint, gives a decision, and the user is still dissatisfied. There is a third recourse available, which the minister also called out in one of the interactions, which is the user can actually file a writ petition under Article 226 of the Indian Constitution. So you see, when we say that the rules are really user-centric and talk about user protection and user harm, the Grievance Appellate Committee actually demonstrates that and helps achieve that, right? And I say, I think this is a major step in terms of ensuring that the users are well protected. So, this was, Manoj, to your point on user autonomy, right? Now, I'll just add a couple of points to what Samir said in terms of, the SRBs, which is when the SRB board members are going to be approving games and declaring them as permissible online games, they will be doing that on the basis of qualitative and quantitative criteria. And, they will look at, how games of skill are defined, what's the statistical data. There is also a very important element here, Manoj, which is there is a pre-approval defined. So while the self-regulatory boards will examine whether a game is a permissible online game or not, they will give a 3-month pre-approval to every game application that they receive. But it is then incumbent on the SRB to make an inquiry, a detailed inquiry in those 3 months, to say on the basis of this qualitative or quantitative criteria, which by the way is yet to be agreed, we are declaring this to be a permissible online real money game. And then the online gaming intermediary will have to say, let's say, Junglee Rummy, right? So we'll have to say Junglee Rummy, verified online real money game, verified by so-and-so on self-regulatory board, right? So that way, a very important element again on player protection is that if any of us make any changes to our terms of service, we have to notify the user within 24 hours, which will be a simple user notification. But this will again make us very transparent that within 24 hours, if I've updated my privacy terms, and I think, Ashish, you faced that at WhatsApp, which is the updation of the privacy policy. Earlier, it used to be on an annual basis. Now it's been made on a 24-hour basis. So in real time, we'll have to inform the user. A third very important change that's happened is responses to law enforcement, right? So all of us receive Section 91 CRPC notices from law enforcement agencies. Now, earlier the regime used to be that within 72 hours of receiving a Section 91 notice or a request from law enforcement, it was mandatory for us to provide the information in our control and possession. It was a legal requirement. For the online gaming intermediaries, the government has reduced that timeline from 72 hours to 24 hours. And And I think we were talking to the minister during the interaction, and we said, why are we being singled out? And he actually said that the same regime is coming now for the social media intermediaries as well. So you see, within 24-hour responses to law enforcement requests, multiple ways to resolve user disputes through grievance appellate committees, the grievance redressal officer, and the writ recourse mechanism as well. Really, I think all these protections are meant for player protection and will help establish a world-class SRB institution. Again, 3 key terms here, Manoj, which is the minister's mentioned repeatedly, which is he wants to see the industry create world-class SRBs on principles of clarity, principles of competence, and capacity and capability, right? So I'll probably just stop here, but I thought that will just give a quick overview on how the players are adequately protected.
Thank you so much, Kapil. In fact, of course, this is a great leap forward in putting a structure into place rather than not having one at all. So now it's when we kind of question some of the features, the idea is not to question the initiative itself, but to see what needs to also be taken into perspective as we proceed further. Because, things that you mentioned just now in the concluding line, that the 3 options of law enforcement officers stepping in and how gaming operators have to respond within a certain time. I believe the law enforcement would come in largely with relation to violation of law, not for violation of the right of one user, so to say, in a particular transaction. So on the larger scale, yes, if there are deviations or non-compliances, law enforcement, any law enforcement officer, depending of the relevant department, may initiate a process. Understood, that's a legal compliance. Ostensibly in the larger picture for user benefit, but then it is compliance of laws. the SRB committee process that the user can reach out, as I mentioned, depending on what is the scale of the dispute, the appetite and resources of the user will get defined to be able to have a sustained, possibility of fighting a sustained dispute resolution process with the operator. So there could be multiple buckets in which you could place different classes of users depending on the quality and quantity or the stakes of the dispute, and therefore kind of make a fair assessment or a broad assessment of where it could be sustainable, which bucket of users may find it sustainable to continue and sustain their dispute to get the desired benefit, and which other bucket has all the avenues, but since they can't sustain it, they don't have resources, so it's in a way denial of their rights. So that's the second part. On the writ part, I don't know how and what is being said, but the writ is already 226 as a part of the Constitution. It does not need to be validated or explained or placed by way of incorporating the opportunity to file a writ in any rules of any department. Okay, and the contours of under what conditions at the High Court in 226, any High Court would admit a writ petition are also there for everybody. All our knowledge, we all lawyers, as a background, whether it writes on a PIL format or it writes on a violation of an individual right format. If it is a violation, that who has violated, if the committee denies, the claim or the story of a user, does every user have to go to the High Court? Is that a practicable dispute resolution mechanism, or is it that they could challenge some action of the government in like even notifying the rules? So that 226 piece is quite a jigsaw puzzle. I don't see that straight away related to any particular user's individual dispute with an individual operator, except where he can keep that as an option to challenge the decision of that appellate committee after exhausting that entire chain. And then also how the court would react, whether the court would see this as the committee being a quasi-judicial body or a judicial body or not, whether SRB is a statutory body, whether SRBs of officers or office bearers are public servants. So there are a whole string of consequences that flow. And I would really like to hear if there's clarity around these issues, which can help the our participants as well. And also, if not, then what can we do to fill in some of these gaps before these rules keep getting challenged again and again and again, and we still take some time to reach anywhere in having a legal this thing. Yeah, of course, Samir, I was coming to you only. So before I move on to Dhruv, wanted a quick recap from Samir, and then Dhruv will come to you after this.
No, I think, kind of, sorry, I just wanted to step into, kind of, so points that you make, Manoj, are absolutely valid. But I think what also has to be seen in here is that, like Kapil mentioned, there is a stepwise ability for people to turn around and ensure that they get their rights protected. But I think, the biggest part here, I would say, is if you look at the current state today, anyway gives all the users and everybody enough rights to protect themselves, because that is in the interest of the industry. I mean, the way I look at it is that it's like, we've heard this story, right? You never kill a golden goose, right? That's how it is. In the sense, so if our player gets harmed, it is our loss. Because ultimately for us, what are we? We are a platform, right? And a platform provides the ability for the players to come and play there. It's more like entertainment. It's no different than what people go to cinema houses and watch movies. It's like you get entertained with this, right? Now, the thing is that the players already have a whole lot of protection, where if they have concerns, they come back to us. We actually sit and solve their problem. We today also have a grievance redressal mechanism. There is a nodal officer. All of that happens. Clearly, the other part is the SRB, with the fact that it is going to be registered by the MITI, and the MITI actually turns around and approves the SRB, will have some amount of teeth for it to turn around and take charge of ensuring that the rules, regulations are being adhered to, and that players, etc., are protected. The other part being the directors are independent, and these are people that includes a nomination from the ministry itself. they will never let anything happen or the independence really get questioned to that extent, right? That's the other part. And lastly, as I said, most companies, and I mean, I told you about our own self here, that we have a full responsible gameplay charter that we follow today. In fact, as I see it, that is only going to get strengthened. It will not get relaxed. Clearly, that is the case. And therefore, I think from a player protection perspective, it is probably in the interest of the industry more than anybody else to ensure that. And that coupled by the various, kind of mechanism now that gets added, I do believe that the players, rightfully so, will get the paramount importance.
Absolutely, and very well said, Samir. In fact, that's what I wanted to bring to home the point, and thankfully you brought it, that I think that trust plays a big role here.
Yes.
And in this whole engagement, unlike any other examples, even I cited an example, many can cite many more examples of how self-regulatory bodies have got derailed the whole process. But here, it's an engaging process, and neither of the two sides can gain without engaging and continuing to engage. And therefore, it's inevitable for you to grow without having a larger class of, or the largest class of users in the world, in India or anywhere in the world. And that itself defines your outlook, and you're not really depending on the rules to create that trust with the users. You have your act together per se, which is what Kapil was also trying to explain. And that itself defines, and the users find they don't need to care about the 226, because the 226 is a very strange journey. So less talked about, the better it is for the users.
I agree.
Yeah. Well, with this, Dhruv, may I request you to come in on the SRB and the dispute resolution process, and now that we see the trust and confidence process between the users and the other stakeholders.
So, Dr. Let's, for example, I personally welcome the rules as one of the sort of groundbreaking steps taken by the government, at least for the industry. But let me play a devil's advocate. Like, let's assume as certain points that you raised, that what is the competency of the SRB in a legal framework, in a constitutional, understanding, what's the legitimacy of an SRB, etc. But let me put it, and when we were talking about grievances, correct? What kind of, how much power the SRB will have or GSC will have and what they'll do about it. Let me put it in this way, that users anyway before these rules already had a lot of civil and criminal recourses for most of the issues they would have had with a gaming company or a platform, correct? They can go to the consumer forum, to law enforcement agency if there's fraud, etc. There are those things. But if you look at the definition of grievances under the rules, as we have said, under 2J, the grievances are only limited to the duties on the intermediary as within the rules, or the content in terms of for the OTT publisher, etc. But so these grievances will be limited to the duty imposed within the rules. The other general harms or issues of the users can be used for different forums and laws already there. So it's not that the GAC or SRB or the company's grievance officers suddenly will take over all the user issues. They don't have jurisdiction over that. So in that sense, all the other harms and general harms that we usually think of, they have the avenues as they had earlier. So it's the grievances will only be remain to the what are the duties under it. Now coming to, as Manoj has said, as Kapil he has also said, that how we are looking at it. So these duties, if you see, these are well-defined duties in terms of when we are talking about, let's say, things like user harm, addiction, the things in terms of warnings that person has to give if they are playing too much, recurrent warnings, self-exclusion, time limit, money spent limit. These are the duties that are being put on the platform so that the user can counter those negative harms if there are any. Correct. There are also duties of having financial protection system in terms of deposits or withdrawals, telling them how you are dealing with their money, telling them what exactly are the rules of the game. So there is a plethora of obligations on the platform. And in this regard, if user has any grievance, they can definitely go to the company and say, see, this is the rule, or this is the, in addition to it, this is the framework of the SRB that you're a member of. You are not following, please follow. In that context, the company most likely, as Samiji said, will follow it. If they don't, they have the GSC. Correct. So most likely what will happen is, in this limited context of these rules, those grievances will be taken on board. And then also you have to understand that the SRB at the end of the day is not all powerful. The MATI, in addition to GSC sitting over them as a appellate committee, MeitY has retained the power to give directions and ask SRB for accountability. Correct. And MeitY has also retained the power to even denotify or de-recognize an SRB. So what will happen is that with the powers under the rules, if the SRB is not functioning the way they are supposed to function, even if the members are paying them a membership fee, let's assume that, correct? MeitY will go and they will get complaints, and obviously MeitY will not want to be seen as siding with the SRB. They will ask for accountability, and if the SRB is not responding to them, they will de-recognize that SRB. So that power is in the rules. I'm thinking there are enough checks and balances, soft as well hard measures in place, and in the long run, it is at the end of the day an experiment. So I think we'll need to give it some amount of time. Just to add another point, SRBs are not a new concept, though this is a very experimental SRB system, but let's say ASCII, correct? So ASCII, in terms of advertisements, already was setting rules, already was setting standards that people were following. They are also SRB, people become their member also. And they have been recognized by the MIB, etc. Their SRB system under the RBI also, their talks SRB, maybe in the fintech sector also. So in that sense, SRB is not new here, though it is experimental here. So I think it's a good experiment to have, and I think is the most robust experiment to have when we talk about user protection in that sense. I think maybe this is a good lens to view the whole SRB and user relationship, which has enough checks and balances.
Sure. Thank you, Dhruv. And I think that's a very important piece you mentioned, that SRB is ultimately registered with MeitY, and therefore their conduct and continued functioning as SRB is contingent on how they conduct themselves and how MeitY has an overarching review jurisdiction over them. May I now request Ashish to kindly come in with your overall perspective. We've heard a lot of these multiple sides to the issue of how things are emerging. What's your take? Is it a boon or a bane? And where do you stand?
I think the experts from the online gaming industry have very rightly put forward their views, and I think it's a good testimony. And like Samir said, that one of the fastest kind of progressing regulation for the fastest progressing kind of industry. Samir, I feel envy being a crypto lawyer. I hope that the government will start paying the same attention to our industry, hopefully soon, inshallah. But now I'm coming back to my topic in terms of the evolution of internet intermediaries, or social media per se as such. I think so. As I said, that it has always been a boon for the industry as such in India, right? Because India from day one wanted to embrace the internet as a means of communication, or as a means of societal kind of connect and sharing of thoughts and all. And the laws have also evolved to support the growth of the industry and the impact of the industry on the society. Now, I think my narrative would be more academic, because I understand that there would be a lot of lawyers and students who are attending this seminar, and they would like to know a bit about how the law and the jurisprudence has evolved, because Section 79 is one of the very, very important section of the Information Technology Act. And if you claim to be a tech lawyer, you need to be mastering the nuances of Section 79 of the IT Act. Now, I think if you see historically, when this law was passed in 2000, right, you can't in isolation read Section 79 unless you couple it with the definition of intermediary, because Section 79 gives the safe harbor to intermediary. In the foundation days, the intermediaries were only limited to somebody who is only helping in exchanging of a message, right? That was a very small nuance of the definition of intermediary right back in 2000. And unfortunately, the word message was also not defined in the IT Act, because it wanted to cover the business cases like Orkut, MySpace of those days, which I'm sure that Kapil, Samir, and I in my age would have enjoyed using Orkut and your Yahoo messengers and all. So law was meant for that. And similarly, Section 79 was not that flexible, because it did not have any non-authentic clause that the immunity is across all the laws. the burden of proof lied on the intermediary, and also there was no notice taken provision. And that is why, when I was fighting for that Bazi eBay case up to Supreme Court, because that case happened in 2008 arena, so we saw those kind of big pain when we were defending. But fortunately, when the things came up to Supreme Court, the regime, the whole ecosystem changed, and the court took a very progressive interpretation of the old laws. But having said that, that's how the law started for the intermediary liability and the definition of intermediary. But then, okay, when the first amendment came in 2008, and that was the most comprehensive piece of legislation that happened in the IT Act, and that really gave the baseline for the hockey stick growth of this industry. The definition of intermediaries got significantly changed, right? And as a tech lawyer, we will appreciate that from the word message, it said that somebody who is like involved in just exchanging electronic records, right? And the definition of electronic record was very comprehensive and expansive. It included images, sound, data, information, which has a very wide definition under IT Act. And I'm sure hardcore internet lawyers would appreciate these nuances. And importantly, Section 79 was totally revamped, in line with what we used to call as DMCA, the Digital Millennium Copyright Act of the US, or Communication Decency Act of the US, because it has very robust notice takedown principle. And the most important part was the law started with a non-obstante clause, right? Said that if your business is covered under the IT Act and the offense you are charged with is under the IT Act, and then you have this immunity, notwithstanding any other law, being in place. And a good kind of framework was also established for the notice takedown, which subsequently, thanks to the MySpace judgment, thanks to the Shreya Singhal judgment, it got further enhanced for the benefit of the social media so-called intermediaries or internet intermediary, that you don't need to have your own proactive knowledge to take a bad content down. You have to be specifically notified, which was under MySpace judgment. Then it said that no, it is not about any random person notifying you. Shreya Singhal came into place and said no, notification has to come either from the court or the designated agency of the government, right? Because I as an individual can't sit on making judgment whether a private complaint is in violation of the law or not. But I think the most important part, which I think further really changed the spectrum of the industry, was the case which was against one of my very dear friend and colleague of eBay, who was facing some prosecution, and also that case also went up to the Supreme Court. And for the very first time, for IT Act, Supreme Court said that IT Act is a specific statute, right? And it will supersede the generic law of Indian Penal Code and others, because the content was on obscenity, right? And it was a question whether he has to be charged both under the Section 67 of the Information Technology Act as well as Section 292 of the IPC. The court said no, the offense happened under the IT Act, and IT Act is a special statute. Section 79 is a full code in itself. You cannot take it away in IPC. So that gave a big boost to the industry. These are few very, very important legal things which entrepreneurs don't appreciate, that how lawyers are contributing towards the growth of the industry and helping them to build multi-billion-dollar companies, right? And then I think post that, when the industry grew very large and it started to have some sort of positive as well as negative impact on social media, on the society, like fake news, lynching, all these things and all. Although there are 95% good things, but the good things come with its own bad things and all. And at that point of time, government felt a need that, look, my hands-off, broad-based approach, time is over. I need to really make sure that there is more compliance and more seriousness in the industry. So then they made very comprehensive I mean, regulation for intermediary, internet intermediary and social media intermediary, significant social media invest. And couple other people have said there is laundry list of compliances. But I would say that these compliances are also good opportunities for lawyers to get enhanced knowledge and understanding how they can be an effective chief compliance officer for a large social media company, right? How can they be a good kind of grievance officer? I mean, what kind of legal training it takes to be a grievance officer? What kind of legal training or education or further enhancement takes to be a nodal officer? And I mean, all these companies, when they start to become big, they become hugely cash rich, right? And I think these roles are very, very high in demand, right? So while yes, it is a bit kind of more compliance burden on the industry, but equally on the other hand, a great opportunity for our fraternity to equip ourselves, enhance our knowledge to get that edge to get into the interview room and prove themselves that they can handle that. But I think there are challenges in the sense that the only worry I have, right? Let's say all the big names which my friend Kapil takes, they are very deep pocketed kind of social media companies, and they can afford best legal talent and best kind of tech talent to really comply with these regulations. I am not too sure whether a startup company could really have that wherewithal money to invest into it. And I think the issue comes solely from the definition or the user threshold for social media intermediary. Because if you are just an intermediary, the compliance level are uh, very less as such. But if you fall in the category of significant social media intermediary, it leapfrog by 10x, right? But the trigger is 5 million users. India may, I mean, I stay in a place called as Andheri in Mumbai, right? Even half of the Andheri would have more than 5 million users, right? So any app which is launched and becomes slightly successful, I'm not saying hugely successful, slightly successful in India, in 2 days, they'll get 5 million users. Now the guy is bootstrapped, right? I mean, you could build that app with just spending 10, 15 lakh rupees, right? And then you are expected to invest, okay, further huge amount in doing all these compliances and keep your 50% revenue reserve for lawyers to fight the cases for you. I think if I were to give one piece of advice to the government, while yes, I think there are plenty of things which the government industry have to relook on the guidelines, is that please increase the threshold from at least 5 million users to 50 million users. Under the Indian context, the most populous country in the world, the maximum number of internet kind of users in the world, 5 million is nothing. I mean, the innovation will get killed, and a small entrepreneur, bootstrap entrepreneur will be scared to really, because one day he can cross 5 million, and next day he could be in jail. And the last but the most important point from a legal standpoint is that the Rule 7 is very, very dangerous. It has totally undone what the Indian Supreme Court has done. They said that any offense under IT Act can only be prosecuted under IT Act. But the Rule 7 says that if you do not follow intermediary guidelines, then you would be liable under any law, including IPC. And unfortunately, Section 66A, which talks about defamation and all, is out of the Information Technology Act. Most of the cases we see in social media, your intermediary is coming out of the defamation, right? The defamation is out of the IT Act. It's only under IPC, right? Or maybe other kind of statutes on SCST and all stuff like that. Now, Supreme Court judgment or Sharad Digumurthy doesn't hold good because your defamation is not part of IT Act. It's part of IPC. You can't claim immunity under Section 79, right? So I think while 66A was read down in Shreya Singhal, there's a need to really bring, let's say, defamation part of the IT Act so that social media intermediaries facing a lot of issues in terms of promoting the content which is defamatory should get good kind of a legal relief. So yeah, I mean, happy days for everybody, happy days for lawyers, happy days for social media intermediaries, but concerning days for small startups who become big overnight. There is a huge compliance. There's a big sword on the head, okay, hanging on them. Government should really give some breathing space to them. So that's what I would just say. Thank you.
Thank you so much, Ashish, for that overarching view and adding so much more clarity to the way the struggles or challenges of the social media intermediaries. And of course, more relaxations are required, but this continuous balancing act between trying to protect the interest of the users versus still giving an environment for startups and IT and social media intermediaries to grow. I think that's a balancing act, and there would always be two views, and I'm sure at some point the government would consider moving the 5 million figure upwards to the multiples of 50 million or closer to that. We have some limited time now as we speak. I'll request all the speakers to try and address two. I had a very important query which I had kept, which I wanted now. There's less time, but still, if you can touch on it, since you all are general counsels of, and Dhruv, of course, as a federation, is dealing with many more such entities. What is the kind of cross-functional coordination, or how do you navigate within your organizations to try and meet these levels of self-compliances and best standards? And now that we have the rules, more of the practical aspects, because we have a very significant number of members from the in-house team, watching and hearing us just now. And of course, what do you see as any open areas which in the rules itself, which need to be addressed? These twin aspects in very short 2 minutes, if you can touch, then we'll quickly take a few questions. There are many, but we'll try and take a few and try and close to as close as possible on the other side of 4:30. Samir, can we start with you?
Sure. See, I think clearly, I mean, they're no different than any industry, any company that kind of operates. Clearly, the lawyers alone or the legal department alone cannot pull off anything, whether it is kind of compliance, whether it is kind of regulations, regulatory compliance, or putting things together. Clearly, every organization has a mechanism. I mean, I can talk about ours. I think it's a very, very what I would say is it's a team which is oriented to get to the solution. Because as a lawyer, I need to make sure that yes, my compliance to the regulations is there and that we are doing the right thing. At the same time, I'm also conscious of the fact that if my business doesn't grow and I don't allow my business to do business, then I'm not sure what I'll be doing right after a while. Because I can comply, but with no business, I have nothing to comply for. So therefore, I think, the good part is, and I think that's where at least I see that as a huge positive in a startup kind of a world, is that everybody just rallies together. And I think this is the time for everybody to rally together to get to the end of it. Purely if I look at it from my perspective, users, extremely important. Therefore, the relevant people within the customer service team must be party to this. The lawyers, of course, have to be part of it. The business heads must be party to it, because ultimately they are the ones who have to answer the P&L, and they're the ones who have to, kind of look at the P&L. If I look at finance, I mean, clearly, again, to ensure that there is compliance, there's a cost of compliance. Ultimately, to ensure that, kind of you're adhering to things, there are, other policies, etc. you will need. So to me, I think the long and short of that really is that, I mean, the team comes together, the team turns around and does the best, keeping in mind the broader parameters and devices ways to go ahead. I think that is what I would say is the best way to go forward. Ensure compliance, absolutely. Do not be non-compliant. I think cutting corners is not something that should be agreed to. And I always say this, and this is something I learned, kind of in my past, and I always believe in this. It is okay to go to the line. You must go to the line because that's your boundary, but never cross the line, no matter what. Because the line is sacrosanct. It is something that I think we learned it right from Mahabharata days, right? Had Sita not crossed the Lakshman Rekha, world would have been different. Therefore, that is how I would always say, do not cross the line. To your point on the SRB, I think, kind of, it is going to be an iterative and an interactive process. Clearly, the MeitY, which has kind of the right intent, clearly the companies and the MeitY will have to work together. I think there will be a lot of areas which I would say are not fully penned down. So nothing can be really, not every T can be crossed and I can be dotted. I mean, that is where it comes out as a joint effort. So we'll have to work closely with them, make sure that every single piece of the SRB, including the requirements, including the independence, including the gameplay, including the user protection, including the registration of the games, etc., and compliance thereafter. I think we'll have to go through this. This is a journey. It's just started. It's a progressive step. It's a progressive journey. It's the start of a beautiful journey. We have to just make sure that this beautiful journey becomes better and comes out with a win-win for all.
Thank you so much, Samir. At least the journey has started, and that's a great thing. So there are so many who are still waiting for the journey to start. As Ashish mentioned, we hope something happens on the crypto side as well. And it has started quite well, leaving a lot of autonomy to users as well as the operators and other stakeholders to put their acts together, get their folks on the SRBs, and then come within the ambit of supervision of the lawmakers and the executive. That's a great start. Kapil, over to you on cross-functional coordination. How do we implement? And of course, any open areas you would want to mention. Yeah.
Absolutely. Thank you. So I'll just add to what Samir said, Manoj. What's going to happen is, look, this will involve a whole lot of stakeholder involvement. It's almost, it's at Junglee, we look at this in terms of, this is almost the gaming industry being regulated almost like a financial institution. So you'll have to set up your first, second, and third lines of defense, which means the business really has to own compliance, and legal and compliance are there to support it. So firstly, I think I would probably start with the bare minimum compliance matrix, which is, this is the requirement under the law, break it down for business, product, IT, tech, and customer support teams. What is their involvement? What is the marketing function's involvement? What is the user experience team doing? Define it for them, and then start aligning and assigning stakeholders and responsible people. If it requires us to make changes to the platform, what does that effort look like? What are the timelines for implementation? It's going to really get down to, the bottom line of let's get compliant, and I think, by the way, what we covered during the discussion today, Manoj, is that because we are part of federation like the e-gaming federation, we already are, almost, kind of 90% down the line, because they have a very well-defined code of conduct. It's now just a matter of mapping if there are any gaps, identifying those gaps and fulfilling them. And, this could be just minor tweaks to the product here and there, but the work doesn't stop there. It'll then be, 24/7 monitoring in terms of, are we doing enough testing of these frameworks to make sure we remain compliant, right? Because there's one thing to create a compliance checklist and assign ownership, but there'll be regular stress testing done. So this is, almost applying the framework of a financial institution, of a bank, and then saying, can things go wrong? Let's predict those wrongs and kind of put in place adequate warning systems. So I would say legal, risk, compliance functions will have to sit together, work very closely in partnership with the business and other stakeholders, and make sure, you're monitoring compliance on a 24/7 basis. So that's some of the things which we are looking at. You mentioned, Manoj, any of the gap areas. I think what two areas where, we probably be expecting some clarity from the government, I think maybe it will come out shortly, is one, and I think there's already work underway on that, is, in terms of what does the KYC requirements look like in terms of, under the rules, because, RBI has various circulars in terms of the KYC mechanisms. The industry wanted a graded KYC, and I think we are kind of moving towards that. The MeitY is flexible on that. And secondly, just the mode and manner in which the SRBs will need to make applications to MeitY to apply, one, to the MeitY for being registered as an SRB, and also the format in which every game will need to make an application to the SRB to be approved. So I think those are 2-3 areas where we are probably expecting some clarity to come out, but otherwise the framework is pretty comprehensive.
Well, thank you. And of course, as you said that apart from these gaps, it has really brought a lot more process into the system with yourself working mechanisms already met 90% of the kind of parameters that the rules have set down. It's a great start, and I'm sure the KYC and the modes and methods of SRB recognition, registration, as well as how SRB would engage in from the operators on registration and recognition of each of the games. All this would fall into place. I guess these are processes. Once the ball sets rolling, once the SRB is in place and recognized, it would issue its own processes. And so would the government, I guess, follow it on. The moment a first letter goes that here I am, register me, they would either, process that application itself, and that would become the process. Or they would come back and say, okay, hold on, we were working on this. This is the set of 10 things, and please comply and come back with a fresh application. So I mean, that's bound to happen. And soon somebody knocks the door of the mighty, things will get clear. Dhruv, I really, before we move on, I liked one piece about Ashish. What he mentioned was that people don't realize how lawyers actually end up enabling or impacting creation or value creation of billions, and therefore deeper engagement with the legal professionals both in-house and outside would help navigate a lot of these processes. With this, I move on to
Manoj. In fact, see, crypto industry itself, right? I mean, it was banned. It was only Supreme Court, and thanks to lawyers who made fantastic argument before the Supreme Court, right? It like unlocked the industry, right? So people don't really think that the deep contribution made by our profession, we just undermine ourselves. No, it's real, yeah.
With you already in the crypto system setup, I'm sure our profile is definitely going to gain a lot more.
So just to add to what Kapil said and Samir said on the gap, I would say enjoy the gap, enjoy the ride. That is where we are in, right? I mean, if all the laws are clear, I don't know we have a job or not.
So Samir Pent, said it very nicely that once there's a line, go to the line, go to the last mile, don't cross it.
Yeah, so, but the miles will, I mean, keep on stretching.
All the gaps are
some boundary will come, but yeah, enjoy the ride, enjoy the gap, right? Just I mean, try
and
to.
That really stands true. Yeah, that stands true for not only operators, also the users. I mean,
absolutely
there for everyone. It's not that when one is talking about a line, one is talking about some mischievous, role play that the operator wants to do on the users to gain some extra advantage. As we said, it's a neutral forum, and both have to engage to create value for each other, for both. Otherwise, nobody creates any value. So that line applies everywhere. So both can go up to the last mile. But just don't cross it, because whoever crosses will get on the other side of law. And with this, Dhruv,
Manoj, can I, before you move on,
sir.
just one lighter side. You know what? I'm really banking on Ashish to ensure that the crypto investments of mine come back up. Yeah, Ashish, it's on you.
Talk offline, right?
There's a lot to talk offline.
Yes, we should.
Yeah. Dhruv, over
Sorry.
to you.
It's a game of skill, Samir, 150% game of skill.
That's why I trust you.
The game of chance bit will be offline. The game of skill can be discussed here.
Yes.
Dhruv, over to you.
Manoj, as I think Kapil and Samir has already taken care of most of the internal sort of cross-stakeholder conversation that need to happen at company levels. So even let's say for in our federation, All India Gaming Federation, so there are a lot of big like unicorns, etc., unicorns, multi-million-dollar valued companies. But a long tail end of our federation is also a lot of MSME sector companies, correct? Like 2 or 3 people running their small companies. And just to pick from Ashish's point is that for the bigger companies, definitely most of the compliance, though challenging, can be done. The amount can be spent on that, and they have the bandwidth. For the smaller guys, we'll have to find a way to sort of help them out generally and to see with that experiment, how much they can manage if there's any issues, whether government can step in and moderate the compliance burden. For example, as Ashish said, that for a significant social media intermediary, the threshold is still 5 million. For an online gaming intermediary, there is no threshold. So even if you have a 5 players or 5 users, and if you are a 10 lakh or a 5 lakh revenue company, you still have to have a compliance officer, a nodal officer, and a grievance officer. But again, we understand it's a sensitive industry, so that there is a need. But there's a thought that might be in next 2 years or 3 years, we'll come back and see. On the compliance, because we are also helping smaller companies with their compliance burden and their internal structure, because they don't have the legal and the compliance bandwidth internally. There are certain tech solutions needed, like, having self-exclusion mechanisms, time limiting mechanisms, warning messages, etc. The KYC bit. There are also certain external solutions needed, external stakeholders like certification or testing labs such as no bot certification, RNG certification. So those things has to be done. There's a big data analytics part also that we think that, as earlier discussed, there will be a quantitative part of testing the game. In that quantitative part, you'll see that a higher skilled player is, one of the principles could be that a higher skilled player is more likely to win, to test whether there is skill. So in that sense, I think we'll need certain data analytics stakeholders also to step in, whether internally or externally. So there are multiple stakeholders, internal and external, and we'll need to also think of the smaller players when sort of developing a frameworks, etc. I think these are few viewpoint points that we should look at in the long run, at least, if not in the short run.
Well, thank you so much, Dhruv. And since we are on the other side of 4:30, we have 12 minutes. Just a quick, maybe we can pick up some of the questions from amongst the cues that we've received from our participants and take it up. Let me start with the first one here on the screen. Any insight on the different definition of online gaming intermediaries, particularly if it covers the ambit of, in its ambit, cloud gaming platforms, which are subscription fee for playing duly licensed games? Anybody wants to respond to that?
I can if you want. Clearly, I think, it's important. The regulations already provide the definition of online gaming intermediaries, and I think it has to be seen whether you fall in that or not. Now, what exactly are you providing in terms of the game, and are you really falling within the ambit, will have to be seen company by company. But broadly, I think the definition that's really given as online gaming intermediary, I think is very, very clear. It says basically any intermediary that enables the users of its computer resource to access one or more online games. And then they've also talked about what an online game is. So I think, as long as you fall within that ambit, you will be an online gaming intermediary.
Sure. Since the answer would lie in the details, I guess.
Yes.
There's one very elementary question, I believe, whether app stores would follow intermediaries. I don't know if that's a. There's a bunch of questions around center state. How somebody, Vivek, is try to analyze in his queues, 4 queues, one after the other, about how the interplay would be between the state and the center. Where would the jurisdiction of one start and end, and how would the jurisdiction of the other get impacted? And therefore, would the gaming stakeholders, gaming operators land up in a conflict zone or in a dichotomy where they get a certain advantage in an overarching framework, but they lose all of that based on each state's approach? So I'm trying to bunch all those queues in one and maybe have your views on that. Samir, can we start with you?
Yeah, sure. So I think, clearly you have to see center and state, like I stated earlier, in line of the fact that what falls within the state ambit and what falls in the center ambit. State is purely gambling betting, which is in simple terms defined as games of chance. So if it's a game of chance, let's say, for example, you are really talking about playing Teen Patti, right? I give that example because that's the most played thing in North. Everybody, does that during Diwali, etc. But if you're looking at anything which is really game of chance, or for that matter, two of us sit and kind of bet on just the outcome of a cricket game to say that, okay, which team's going to win today, and, kind of between us, where we have no skill involved, or we are not even participants there. Clearly, that's a game of chance. That's gambling betting, and it falls within the gambling laws. In fact, if you see, there is a gambling law, and then every state has passed gambling laws, kind of surrounding it with a modified, etc. That's the state ambit. Skill is purely what is predominantly defined as a game having skill. These are, again, games like rummy, poker, fantasy. These are all being held as games of skill. Chess, as games of skill by the courts itself. That is what will fall within the center ambit, and that's what really an online game of skill will be. I think that's really the broad, differentiation there I would put. Just before you go, the one thing I just want to rectify, I think I said, Lakshman Rekha from Mahabharata.
I saw that comment as well. That's fine. I think
just thought
we all know. We understood the line, the line with compliance.
Yes.
Yeah. These are hardly issues. And of course, Dhruv and Kapil, you want to add before I come to Ashish?
Sure. On the state bit, I think we just said, so it's very clear that state can only regulate games of chance and betting and gambling under entry 34 of the second list of the second schedule. And anything which is not game of chance or which is game of skill is to be regulated by the center. And that has been clarified in multiple high court decisions as well. However, what we also have to understand that recently what we have seen is that it can happen that state may try to define a game of skill as game of chance. But state doesn't have that competency, at least that's our opinion, that it is a factual question. The Supreme Court has already given a factual definition of what a game of skill. It is basically if you have predominance of skill in the outcome of the game, it is a game of skill. So by calling an orange an apple, you can't make orange apple. So in that sense, it's definitionally very clear. States can only deal with game of chance. Center will deal with game of skill. However, yes, I read some of the questions. A center might confuse these concepts, may come out with the law, and then I think Samir and Kapil definitely will go and fight that out, and the magic of Article 226 will take place there. But I mean, that's the Indian law for you. That's the idea of federalism in that sense. But the concepts are very clear, and I think slowly as these rules are applied, I think states will also get to learn that let's focus on games of chance, betting and gambling. There are bigger things, offshore betting and gambling sites and etc. that they should be going after and actually stopping, and not trouble the legitimate businesses, which are only running games of skill. So that's my view on the state.
Thank you, Dhruv. Kapil, over to you.
Just to add to what Samir and Dhruv said, Manoj, look, I think in terms of the legal analysis, these rules really are framed under Section 87(1)(z) and ZG of the IT Act. Now, the IT Act is the central legislation. So clearly, two things have happened. One, the rules themselves derive their powers from a central legislation, no doubt about it, which is the parent legislation. Second, the allocation of business rules 1961 itself was amended in December 22 to declare MeitY as the nodal ministry for online gaming. Third, entry 31, list 1 talks about wireless, under which the government occupies the feed on anything happening on the Indian internet. And the minister has clarified that multiple times. How the Indian courts will now interpret the balance between entry 31, list 1, these rules, and gaming and gambling and betting, which is a separate subject under the state list, entry 34, list 2, right? So I think in the ultimate analysis, this is an occupied field, online gaming, no doubt about it. These are legitimate businesses run under 19(1)(g). We all have the freedom of protection under 19(1)(g), subject to the restriction under 19(2). So there is a constitutional backing, a series of Supreme Court judgments, as Samir called out. So I think it'll now be essential to see, what attitude the states adopt to it. We can only hope, they let the industry flourish, and these games really play out, and with the self-regulatory boards coming in, I think we'll get that much needed clarity.
Thank you so much, Kapil. Ashish, you want to add to it as a concluding?
So nothing on the online gaming side. I'm not the expert, and we have industry's best 3 experts here. But I would say that I think the question is more political in the sense that how the central government, state government, their powers are divided and how they are exercising their powers. And I think social media industry has always been at the receiving side of the stick and all. So I think so internet is in India is mainstream, and we have realized, we are online now, right? It's like we are meeting online. Internet is the lifeline of India. Internet is the lifeline of society. Internet is the lifeline of the business, right? Now definitely it is not only in India, across the world, right? We have seen in in the Western countries, in all democracy, those which are not democracy, there will always be a tussle between what kind of freedom people have to exercise online, which is kind of censorless, and how governments would want to really check and absolute kind of freedom, right? Whether for good or bad and all. So I think there's always a tussle which will continue to happen. I personally don't think there is a straitjacket formula. It has not been found across the world. I don't think even blockchain solves it, because in my industry, people say blockchain solves everything. I don't even think blockchain can solve this industry. But yeah, definitely, I think, as I said, this is a gap, and this gap is going to persist throughout the journey. And I think we being lawyers have to embrace it. And like Samir said that, we should not cross line, but in case we are crossing line, we are crossing the line to do the right things, right? Not to do the bad things. Yeah, and I think my only thing, the only thing which I fear for social media is that the rule 7 is like too open-ended, and I think there is a need to really bring a proper law on defamation, both online offline, and especially it should be brought in the IT Act as soon as possible, because that's a big gap for the social media intermediaries to even put reliance on the Sharad Digumarti case and say that, I'm only an IT platform. Why are you prosecuting me under IPC for defamation? Yes, they can be, because defamation is out of IT Act as of now.
Thank you, Ashish. And that was a good one you mentioned just now, that the line can be crossed, but for the right purpose, the good objective. Interesting. And I hope we can take a cue from that and try and have a perspective around that from the government as well. That not every time that a line is crossed, it's meant for a objective which is against the interest of the user. It could be inadvertent, it could be for the right purposes, it could be for areas where the government has had an oversight in analyzing the future. On the center state bit, before concluding this, my one line I could resist adding is that, once the legitimacy piece is taken care of by the rules, only two things remain. One is the political conflict zone, the outlook of a state being defined by the political dispensation or the conflict of dispensation. And the other very important piece across, which we've seen in even the tax side, is what is the revenue gain they are looking at from the piece. So if they get their pie of the cake, and they are not in that conflict zone of political no-go for anything that a center has provided, I think those states should be home with this. So I think we expect largely most of the parts of the country to be at home with what center has done, barring some who would, I guess, whenever these factors fall out, the political one particularly, they would also. So we don't see a reversal of this process in my perspective. I think I see this going to the full mile to the end. In some states, it may take a little longer, but then it's definitely here to stay, and a very good beginning. Well, with this, unless anyone has any other concluding remarks, I'll just pause here, or then we can end the session today. It's been a very exciting discussion. Samir, any concluding remarks from you?
Oh, I think thank you, Manoj, for this exciting time. I didn't realize we're nearly 2 hours into this.
Yes.
I don't know how time went, and clearly, fantastic. Thank you for this opportunity. It's great to be here with Ashish, Kapil, and Dhruv. Of course, you've been a fantastic moderator, but I think, as I said, progressive step. We are in for the long journey, and I think it's all going to be good in the future.
Well, thank you, Samir. And of course, we intend to continue the initiative by taking the thinking process to the last mile as well as hosts. Kapil, any concluding remarks from you?
Thank you, Manoj. Appreciate the opportunity, and to all the co-speakers, Ashish, Samir, Dhruv. This has been a fantastic panel. I think we didn't realize 2 hours just went by in a jiffy. And I would just add the point on innovation, Manoj. Huge opportunity for the industry, huge opportunity for India, in fact, to create a world-class self-regulatory framework on gaming and further foster the journey of innovation and user growth, and create, obviously create many more unicorns in this sector. Thank you.
Thank you so much, Kapil. Dhruv, any concluding remarks?
Dr. Manoj, I think, again, echoing the sentiments across the board, fantastic session. A lot of nuances were brought out, and I think there's a need whenever such experiments happen, whenever such new regulations come, there is a need to have those nuances discussed from multiple perspectives. And I think just to add, I think already we are seeing a lot of investors, foreign investors and even domestic investors getting excited about these rules. A lot of people trying to develop new products. So I think overall, it has been received very well. And I hope that in next 2 years or 3 years, even other sectors will also see such experimentation in terms of self-regulation or other kinds of sandbox approach or whatever it is, from the Indian government to sort of give a boost to that $1 trillion digital economy dream.
Thank you so much, Dhruv. Ashish, any concluding remarks?
Yeah, so I will not repeat that all the kudos to you, but I think I would only say that a specific kind of call out to our profession. I think we have done a lot over the last 20 years to really bring India at a faster pace in the digital evolution, but we are not being recognized. We lack our share of recognition in the ecosystem, right? I mean, we are not being thought as the first kind of. I mean, very rarely I've seen any kind of startup founder saying, "Hey, I want a lawyer as a co-founder," right? They'll say, "Oh, I want a tech guy as a co-founder. I want to get an operations guy as a co-founder. I'm going to get a finance guy as a co-founder." Why? When we have played enormous key role in building this. So I think my appeal is to our fraternity as such, through you, Manoj, and through this forum. What can be done to evangelize, to promote this great role played by our profession in building this fantastic industry? We just get unnoticed, right? We are underdogs, we just get unnoticed. What can be done by all the people in our profession to put our profession in the front line, right? The first thing which any startup founder thinks whenever he has to start a business, can I have a lawyer as my co-founder, not as an advisor? That way, I think I would see that our industry, our profession has got the full recognition and reward by promoting and progressing this industry. Let's do that. And also equally to my lawyers friends, look, there's a huge opportunity. It's a huge opportunity. We should invest. We should continue investing time and money in upgrading our knowledge, right? Make sure that you have the right skill set, if not practically, but academically through specialized institution. How can you be the most effective chief compliance officer of a Twitter? How can you be the most effective grievance officer of a WhatsApp or of a gaming industry? So it's an onus on us to really latch on this opportunity. It's a huge opportunity, huge job opportunities in this industry. We just need to start thinking about investing more time and money to hone our skills.
Thank you so much, Ashish. That was a very valuable thought, and we should build on it as we go forward. I think accolades and validations from agencies who are in the business of giving accolades and validations are not enough. The real value of our contribution to shaping up the future of some of these sectors should be recognized by these sectors and stakeholders themselves, by having us on board. Very well thought, and of course, this needs to be built on so that it could be an incentive and brings a far deeper commitment. Well, thank you so much to each of you for taking out time. It meant a lot. 2 hours have passed, but the quality of discussion, we didn't realize the time is purely because of the maturity and wisdom that each of the minds brings on the screen here today. I dare say table, say screen. And therefore, Samir, Kapil, Dhruv, and Ashish, thank you for taking out time. And we hope to do more of these sessions to discuss the nuances and try and overcome some of the open areas and gaps. With this, I'll close the session and see you folks soon, especially offline for a lot of discussion that Samir did flag. So we'll catch up on that.
Thank you.
Thank you.
Thank you.
Thank
Thank you,
everybody.
everyone.
Thanks.
Bye.